This lecture will be discussing occupiers liability. I think this is quite a long topic, but the good thing about it is it's quite statute based, and also all of it has cases to back up as well. So the main statute in which this is contained is the Occupiers Liability Act. There are two. One is a 1957 Act. This applies to visitors and it allows covering of personal injury and property damage, whereas the 1984 Act applies to trespassers and only covers personal injury. So, looking at the 1957 Act, it talks about visitors and occupiers. It basically says that you, as an occupier, owe a duty of care to the visitors which come onto your property. And the question of who is an occupier isn't defined in the statute, it's more based on case law. And in Wheat and Lecon, it was said that an occupier is defined based on who has control. So if you're the person renting, so in Wheat, the pub owners, so whoever owned the property, wasn't liable, whereas the people who owned the pub itself were, because they were there on a day-to-day basis. They knew exactly what was wrong and they had the power and control to be able to fix that issue. So with visitors, there's this whole idea of permission. They have permission to be on your property, and there's express and implied permission. So in Coregraph, it basically says you're invited to use a property reasonably. So if you're in a property and you need to go up the stairs, you're allowed to go up the stairs. You have that permission to walk up those stairs. However, you don't have permission to roll down the stairs or jump down. You have to use it in its ordinary way. And there's also implied permission. So this is basically the idea that they don't have permission to do that specifically, but because they are there, it comes along with it that they would be able to do so. So in Harvey, they were running away and they were allowed to be on the property. It was council owned. However, the fact that they were running away on it while they were drunk and then ended up falling, that caused them they were caused to lose damages as a result of contributory negligence. Their damages were reduced. However, it wasn't the fact that they weren't allowed to be on the property. They had permission to be on that property and to walk across it, to run across it, whatever. However, if they do this unreasonably, they can have their damages reduced. There's also this idea of the doctrine of allurement. It talks about children, which were also discussed in section 2(3)(a) of the Act. So it basically states that as an occupier, you should expect children to be less careful and less aware. So in Glasgow, there were poisonous berries on another side of the fence, and yes, the child did not have permission to pick this berry. However, if they're on land and a child sees berries, they are likely to pick it. It is something that the occupiers should have in their minds and try to safeguard against. Again, the same applied in Jolie and Sutton. So the boat was abandoned in a park. It's clear that children are going to want to play with this and go near this. And when the boat collapsed and I think killed one of the boys, liability was found because the council should have known to remove that the boat in the park. However, this doesn't mean that children aren't being looked after by their parents. Their parents still have that responsibility, and that was made clear in Phipps. So it basically said that parents can't delegate their responsibility. If you as a parent take your child somewhere that they shouldn't be, or allow them to do something that they shouldn't, the occupier isn't liable for that. So if your friend comes over with their child and there you have paintings on the wall and this child decides to touch them, if their parent allows them to do so or tells them, oh, look at that, go do you want to touch it, something like that, that parent is still responsible. You can't get rid of your responsibility as a parent. There are also a lot of circumstances which have to be considered. These were listed in section 2(3) of the Act. So it basically says that these have to be considered in seeing whether or not the defendant has breached their duty. So you have to look at how serious the potential harm is. The more serious it is, the more likely liability will be found. The cost of preventing it, if it would have been very cheap and proportionate to fix this issue, you should have done it. And again, the likelihood of the harm occurring. It's this whole idea of foreseeability. No one's going to safeguard against negligible risks. And lastly, the utility of the defendant's occupation, how useful was not fixing this issue or having this certain issue there. So an occupier is able to leave, like, it's kind of like getting rid of that duty where there are experts and special risks that the occupier doesn't need to necessarily be aware of. So this is a lot clearer looking at cases. So if you look at Rolls and Nathan, there were chimney sweeps and they went into the chimneys while they hadn't turned off the chimney properly and this gas was still in the air. This was a risk that they should have recognised themselves, and the occupier should not have been liable for their failure to do so. The occupiers can discharge their duty in various ways, such as the use of an appropriate warning. So in White, it basically says that the warning has to enable the victim to be safe. So rather than saying, do not do this, like do not cross this bridge, you have to give them an alternative. So do not cross this bridge, use the one 5 meters north, something like that. However, in Clark, it says that this is again only expected to be at a reasonable amount. So where there was, I think there was a sign saying there's a ramp here for wheelchair users, however they hadn't put one on the other side. There was no need to do so. They were reasonably safe. They were aware that it existed on the other side. So where you give notice and an alternative, your warning may be used to discharge your duty. You can also discharge your duty where there are independent contractors. So this allows discharge where it is reasonable to entrust the work to an independent contractor. The occupier took reasonable steps to satisfy themselves that the contractor is competent, and they took reasonable steps to ensure competency and that the work was done properly. So in Hazeldine, there was a repaired lift, however the lift dropped. It's reasonable to expect that the person repairing the lift is the expert and is the person who is meant to have repaired this and is responsible for ensuring its safety and that it is done properly. Again, we can look at Maguire. So this was gym equipment. It was questioning who's responsible for looking after this gym equipment and making sure it's safe. And it was reasonable to rely on the contractors to test for its safety. With occupiers liability, there are 2 defences. You can use contributory negligence and also consent. A lot of the times, occupiers try to exclude or restrict liability where they shouldn't, or it's unreasonable to do so. You can use the Consumer Rights Act or the Unfair Contract Terms Act in order to fight against these, and it's such as in cases of death and severe personal injury, you cannot exclude liability for that, and that's clear using these acts. We can then look at the 1984 Act. So in the 1984 Act, we look at non-visitors and the occupier's duty towards them. So in section 1A, it basically says that just this duty is only in relation to personal injury, unlike with visitors where it's personal injury and property damage. And this duty exists where the defendant is aware of or has reasonable grounds to believe in the existence of danger. An example of this was in Donahue. So I think they dove down, hit something where they shouldn't have. It was a dangerous activity by the claimant, and it was an obvious risk that the claimant undertook, and so it would be unreasonable for the occupier to be liable for that. They would never think or reasonably think that someone's going to undertake this risk. And again, it was the whole concept of there has to be something wrong with the state of the premises. There was nothing actually wrong with the state of the premises, and that this harm only arose out of the claimant's own actions. This is very similar to Coventry Healthcare NHS Trust, where a child used a fire escape as a climbing frame. Again, this was the child's own actions. There was no issue with the state of the premises, and so the defendant shouldn't be found liable. This is where there are reasonable grounds to believe that the non-visitor is or may come into the vicinity of danger. They would not believe that that anyone would use a fire escape as a climbing frame. If you cannot reasonably believe or foresee this, you cannot be found liable for it. Again, similar to the 1984 Act, there's this whole concept of children are expected to be less careful and should be looked after more precautions should be taken. So in Platten, Liverpool City Council, there was an abandoned house, and children went inside and they were playing, and the house collapsed. And it was held that the defendants took reasonable safety precautions. They had boarded up the house, yet the children still managed to go inside. It's this whole idea of what is reasonable. They took reasonable steps to safeguard from this risk. They cannot be expected to do any more. Again, similar to the 1957 Act, you can discharge this duty with reasonable warning. And again, there are defences of contributory negligence and consent. So one thing I thought was weird with this is, why should you be protecting trespassers? So say someone breaks into your house, why should I have to protect them and compensate them for them breaking their leg when they were breaking into my house? It doesn't make sense. However, in British Railways Board in Harrington, they basically said that occupiers owe non-visitors a common duty of humanity. It's this whole concept of fairness, morality, etc.